falls to me this morning to welcome you to the United States Institute of Peace. And I'm particularly pleased to welcome you here today to discuss a topic which has anchored my own interest and passion in rule of law work, both in my own country and internationally, prisons and detention. It's not every day in this particular field that we have something to celebrate. Sometimes it can feel a little bit bleak to do prisons work, but that's what we have today. We're here to celebrate, to discuss, and assess the implementation of, and talk about the future of the new standard minimum rules for the treatment of prisoners. Their revision took over 4 years to negotiate. Many of the people here today involved in that difficult process and long process, and was greeted with spontaneous applause upon their agreement in May in Vienna. They'll now move to the UN General Assembly in New York in September for hopeful adoption, and they will do so bearing a new name, the Mandela Rules. And this is in recognition of a man who spent 27 years of his life held in harsh prison conditions, denounced as a terrorist and a criminal, but also led his country, dismantled apartheid, and inspired the world. And sometimes I feel that in my own prisons work, that it's almost taken me through every shade of humanity and inhumanity. From a prison in Eastern Congo that I visited where they'd had no water in their tankers for almost a week because the governor left town and there was no gas in the trucks to fill the tanks. Where prisoners slept in shifts because there wasn't enough space for them all to lie down at the same time. Then to a rural prison in Liberia, where I met a Ghanaian UN corrections officer who had not only been dipping into his own pocket when he first started in order to feed the detainees in his care, but actually then started a prison farm system. That years later, when I went back to visit, is not only making that prison self-sufficient, but is actually feeding a number of the other prisons and its goods being sold at market. And then to another darker case where I visited a female block in a prison, already not ideal to have that situation, but it had no proper gate blocking the main prison population from entering, and where almost every one of the 60 female detainees was either pregnant or carrying a small child. But through every visit and through every project and through every piece of work, one thing is constant, and that's the SMRs, the standard minimum rules. I reread them every time I start a new project. They're always with me. They're folded up, they're a neat little thing you can fold in your back pocket. They're crumpled in the bottom of my handbag, but they're there because they are the touchstone in this work. And that's why gathering this group here today to discuss them is so relevant. And so I want to introduce the panel. We have a great mixture of both sort of national and international prisons work here today. Firstly, David Fathi, Director of the National Prison Project at the American Civil Liberties Union, who has worked and dedicated his career to addressing challenges of conditions of confinement in prisons, jails, and other detention facilities, and works to end policies that have given the United States the highest incarceration rate in the world. He's worked as a staff lawyer at the project for more than 10 years and then became the director in 2010, also having worked as the director of the US program at Human Rights Watch and participated in the negotiation process of the new standard minimum rules. Next we'll have Mark Linning. Mark is the protection coordinator of the International Committee on the Red Cross for the regional delegation of the United States and Canada. And in his capacity, he's in charge of coordinating ICRC's visits to Guantanamo Bay, as well as issues related to the detention operations, the protection of civilian population in Afghanistan, and other relevant contexts. And Mark will talk a lot about the work also of ICRC on the ground. And ICRC, I think, has a very special role and a very important role. They are working every day in prisons around the world in nearly 100 countries, visiting prisoners, checking conditions, speaking to detainees, helping detainees to communicate with their families and the outside world. And they are so vital to giving us a flavour and a picture of what detention really looks like and conditions really look like. And finally, today we'll have Pat Prue, attorney advisor at the US State Department, also working at Georgetown University as an adjunct professor of law. And Pat has served as an expert on the United Nations working groups, focusing on extradition, the standard minimum rules of treatment for treatment of prisoners, killing of women and children. And she served on US delegations at the UN Convention against Transnational Organized Crime, UN Convention Against Corruption, Commission on Crime Prevention and Criminal Justice, and the list goes on and on. But first I'll turn to David Fahy to begin.
Thank you, Fiona. I'd like to thank the United States Institute of Peace and the Department of State for organizing this important event to promote and publicize the Mandela Rules. I'd also like to acknowledge the person in whose memory we gather here today. Nelson Mandela was imprisoned for 27 years by the apartheid regime, during which time he endured hunger, physical abuse, and solitary confinement. He emerged unbroken as a towering figure of national reconciliation and the first president of a democratic and non-racial South Africa. And so today, on the eve of what would have been his 97th birthday, we remember him and we honor his sacrifice and his legacy. The Standard Minimum Rules for the Treatment of Prisoners, or SMRs, are the leading international body of principles on the treatment of detained persons. In many countries, they are virtually the only standards available to prisoners and to prison staff regarding treatment in detention. In other countries, they form the blueprint or the basis for national prison rules and regulations. Here in the United States, we have a considerable body of domestic law on conditions of confinement that's been developed by our federal courts, but the SMRs are still important. They've been cited by the Supreme Court as well as lower federal courts. The State Department uses them in assessing prison conditions in other countries, calling them the most important set of guidelines for evaluating prison conditions. And at least one Department of Corrections in the state of Connecticut at one point actually adopted the SMRs as part of its administrative regulations. But the SMRs had become outdated since they were first promulgated in 1955. They used archaic terminology, for example, referring to mentally disordered persons. They failed to take into account recent technological developments. And probably most importantly, they simply failed to address a number of very significant issues, such as, for example, the needs of prisoners with disabilities. And so in 2010, the United Nations General Assembly asked the Commission on Crime Prevention and Criminal Justice to establish an open-ended intergovernmental expert group to revise the SMRs. At its first meeting in 2012, the expert group decided on a targeted approach and identified 9 specific areas of the rules for revision. The expert group also agreed that any changes to the rules should not lower any existing standards, but should instead reflect recent advances in correctional science and best practices. The expert group met 4 times between 2012 and 2015. NGOs from around the world, including the ACLU, were actively involved in the latter 3 meetings. I represented the ACLU at the 2nd and 4th meetings in Buenos Aires and Cape Town. Our goal in the NGO community was a progressive revision of the rules that would take into account the many developments in international standards since 1955, including the many human rights treaties that have come into force since then. To coordinate and present our recommendations in an organized fashion, we convened 2 expert meetings at the University of Essex in the UK in 2012 and 2013. These expert meetings resulted in a document known as the Essex Paper, which laid out current international norms and standards in the areas that were proposed for revision and recommended specific changes to the rules in those areas. In addition to the NGOs, there was active participation from various UN human rights bodies, including the Office of the High Commissioner for Human Rights, the UN Special Rapporteur on Torture, and the Committee on the Rights of Persons with Disabilities. The final meeting of the expert group was held in Cape Town in March of this year. At this meeting, the experts reached consensus on revised rules in all of the designated areas. And meeting just a few miles from the infamous Robben Island prison where Nelson Mandela was held for so many years, the expert group recommended that the revised SMRs be known as the Mandela Rules, and that July 18th, Mandela's birthday, henceforth be known as Mandela Prisoner Rights Day. The expert group's recommendations were unanimously approved by the UN Crime Commission, meeting in Vienna this last May. Now, it probably goes without saying that the final text of the rules is the result of many compromises, and not all of the NGO suggestions, proposals were accepted. But the NGO group strongly supports the Mandela Rules as a major step forward, providing greater protection for persons deprived of their liberty and recognition of their rights, as well as more up-to-date guidance for prison staff. We think it's particularly significant that the revisions bring to the rules a human rights focus that was previously lacking. And they successfully reconcile criminal justice standards and human rights standards in a single instrument. I'm very glad to be here today with Pat Prue, because I would particularly like to acknowledge the progressive and constructive role that the US delegation played in this process. The US has been a strong supporter and proponent of the Mandela Rules and fought back successfully against proposals to reopen the agreed text and water down various important standards. Let me give just a couple of examples of significant changes made by the Mandela Rules. Solitary confinement is a human rights issue that is receiving increasing attention. As you may know, in just the last few weeks, President Obama and 3 US Supreme Court justices have all denounced solitary confinement. Mandela himself called it the most forbidding aspect of prison life. And in 2011, the UN Special Rapporteur on Torture released a global report on solitary confinement, concluding that in some circumstances it can constitute cruel, inhuman, and degrading treatment, and even torture. Since 2010, we at the ACLU have led a national and increasingly international campaign against solitary confinement, so this issue was of particular importance to us. The original SMRs were silent on solitary confinement. By contrast, the Mandela Rules provide that solitary confinement shall be used only in exceptional cases, as a last resort for as short a time as possible, and subject to independent review. Indefinite solitary confinement and prolonged solitary confinement, defined as more than 15 consecutive days, are prohibited. Solitary confinement is not to be imposed simply by virtue of a prisoner's sentence. So, for example, simply because a prisoner is sentenced to death or to life imprisonment. Solitary confinement is also prohibited in the case of persons with mental or physical disabilities, when their condition would be exacerbated by such confinement. Healthcare is an area of great concern to prisoners. Prisoners as a class had greater health needs than the general population. And obviously, if the prison doesn't provide health care, prisoners will not receive it. The Mandela Rules significantly expand and strengthen the provisions on health care for prisoners. They make clear that health care in prison is a state responsibility. It must be provided free of charge, and that prisoners should enjoy the same standards of health care as exist in the community. Prison health staff have a mandatory duty to report any signs of torture or ill treatment or any indication that a prisoner's mental or physical health is being adversely affected by conditions of confinement. Now, words on paper by themselves don't change the world. And the real work, ensuring that the Mandela Rules will make a difference in the lives of the millions of prisoners in the United States and around the world, begins now. We and other NGOs are planning trainings and other events, and this is a top priority for those of us in the NGO community that participated and took part in this long process of bringing the Mandela Rules to completion. The U.S. delegation in Vienna included the heads of two state prison systems, Colorado and the state of Washington. And I know that they are working as we speak to publicize and promote the SMRs among their fellow corrections administrators. Much work remains to be done, but today's event is an important first step. And so I thank all of you for your participation, and I thank you for your kind attention.
Mark.
Well, thanks, Fiona. Thank you very much, USIP, for inviting the International Committee of the Red Cross here today, and the opportunity to share some remarks, not only on the SMRs and the process and how the revision came by, but also how we at the ICRC uses the SMRs, intends to use the SMRs, the revised version of it, also in the future. The ICRC works worldwide in more than 90 countries. Last year alone, we visited more than 800,000 detainees of different categories to look at conditions of prison, you look at the treatment, to look at other aspects maybe linked to judicial guarantees, to the outside contact of detainees with their families, etc. So giving you a little bit of an operational perspective how also the ICRC intends to use this vital document on the ground is something I'd like to share some remarks today on. Maybe before that, though, of course, also I'd like to, on behalf of the ICRC, express the appreciation for having been invited to be part of the revision process of the SMR from day one, to be able to contribute its perspectives, especially on topics of focus of the ICRC, looking at prevention of ill treatment, torture, looking at solitary confinement, as you mentioned, family contact, but also looking at aspects that sometimes go a little bit under the radar in terms of focus, like medical ethics, medical care in prison. The ICRC also would like to really express its appreciation of the role of the US government and its support throughout the process to get where we are today. And we hope that that positive attitude, of course, will also help the formal adoption at the United Nations General Assembly later on this year. Again, once this revised version has been adopted, it's going to be part and parcel of our work when it comes to our protection delegates, our legal delegates working in prisons worldwide. And we really like to use this as soon as possible. The way we see at the ICRC the SMRs is rather as an practical guidance tool that should be aimed at the prison administrations, at the prison wardens, at the stakeholders on the ground. And of course also then looking at the problems and the many humanitarian consequences sometimes we see in prisons today at the wider echelons of stakeholders in different contexts that affect prison conditions. So of course there are many issues that can be tackled in prisons themselves, but sometimes of course it's the more systemic issues and root causes that lie outside the prison system itself that affect the lives of detainees. And then one has to talk on different levels with different ministries, different stakeholders to try to affect change. So again, the implementation part of it, of course, the contextualization of those rules in the different contexts, how to operationalize them, how to integrate them in prison systems that exist in different cultures in different countries. That's, of course, lays at the crux here of this issue. And of course, the SMRs provide a great first step, but it is only a first step. Unlike my co-panelists, I didn't have the privilege to be part of that revision process. But again, when we look at what the ICRC does worldwide, I'd like to give you some examples. For example, how this can be applied, how the SMRs can be used when negotiating with the different stakeholders on the ground. One of the main issues, but it's just an example, it's just one, looking at overcrowding, for example, in prisons and how to affect the issue of overcrowding. Oftentimes, the sheer knowledge of having baselines in terms of how much space a detainee needs, what systemic effects need to be tackled in order to provide detainees with more space. When it comes to the use of preventive detention, when it comes to keeping people waiting for trial for excessive periods of times, because the legal system is flawed or because the coordination between different ministries is flawed, and then the effects of that on the ground. Those kind of realizations, they might seem obvious now to us here on paper. It's easy to discuss this. But oftentimes the mere existence of such standards, ratified or formalized, adopted, is something that is not known to people on the ground. So when we visit prisons worldwide, the sheer dissemination, the sheer awareness raising of the SMRs is a vital first step. And then to bring the people together, and oftentimes they really want to do something about it, but they just don't know how, and that's where the practical side then comes in. And we, as the ICRC, we visit prisons in a certain way that should help then also those different authorities to make moves and to try and find solutions. We, of course, we conduct prison visits, speaking with detainees in private, speaking confidentially with the different prison authorities, provide then recommendations, findings based on our own observations as well, and of course on our expertise in general about prisons, and to try to bring that together with the different insights of the prison authorities on the ground. Sometimes, the notion of the need to have access to families when you're in prison, it sounds pretty straightforward. Looking at the situations in many places of the world, however, it is actually much less straightforward. So finding creative solutions, for example, via video telephone conferencing, where prison visits cannot be done by the families themselves. When we look at a situation like in Yemen, for example, right now, families are on the move in Yemen. It's a war-torn country, but maybe they have relatives that are detained in a prison in the US, in a prison in Europe, in a prison I don't know where. How to reach those families, how to then be able to appease the minds of the detainees who are obviously very worried about those families, trying to get in touch, recording safe and well messages via being in touch on the phone with families, and then bringing those into the prisons. Having the prison authorities realize also the benefit it has for them when they're able to then deliver and quickly clear those messages to have a calmer prison environment with less mental stress and emotional stress for the detainees. We have other issues in terms of medical ethics that sometimes are not featuring on the radar of detention authorities. An example could be, for example, the use of interpreters in prisons. When there's a dual use of interpreters, for example, for interrogators and for medical care. All of a sudden, you have detainees, of course, who are not anymore at ease to even speak with the doctors via their interpreters, because that the same interpreters might be used for interrogation. Then medical care is affected, and of course, the humanitarian consequences are obvious. It goes without saying that I think also beyond the mere humanitarian consequences, I think for society in general, is that it is important to have humane prison conditions. I mean, some key words that come to mind are recidivism costs, are radicalization in prison, etc. So there too, I mean, beyond the pure humanitarian objectives, there are other objectives that are worthwhile as well to look at here. Maybe to give you a couple of insights again, how the ICRC is currently looking at the prison landscape worldwide. In addition to, unfortunately, the continued disrespect in many contexts of blatant violations, blatant notions of humanity in terms of summary executions in prison, arbitrary detention, torture, or treatment, we see a lot of systemic issues. Again, I mentioned overcrowding, but also lacking infrastructure, inadequate management of prisons, inadequate training of guards. I mean, guards too have to be really be mentioned here, because without them obtaining adequate training, how can you expect them to work in sometimes very challenging conditions? The use of force, even inside a prison, by the guards. This is something that is not obvious, but how to escalate force is complicated in general. In a prison setting, how to use certain devices to try and maintain the calm is even more complicated, and therefore training of guards cannot be overstated enough in terms of also leading to positive effects for detainees. Having said that, we also still, of course, see problems in terms of the high security prison model. It's still something that has been on the increase overall globally, something that we see with concern. On the flip side, there is still, in our view, less emphasis, or not enough emphasis, on also looking at alternatives to detention, thereby tackling overcrowding, for example, for, let's say, migrants who were purely detained because they migrated without documents, or let's say minor drug cases whereby the whole prison system is suffering as a result because of the effects of that. And there are more and more quite creative ideas about alternatives to detention to look at remedies there. Last but not least, maybe let me just give one more example from the ICRC perspective, whereby the respect of the SMRs and the need to disseminate and implement and adopt them, of course, it cannot be overstated enough as well. And that's when we have also, of course, the ambitions to not only look at detention places that are run by states, but more and more often also by non-state actors globally. Of course, they more or less, not often, not always, but also look at practices by state in terms of detention. So the adoption of those rules is then also a tool and a vector to also discuss, sit down, and try to convince non-state actors to adhere to the rules, the vital rules, the positive rules of those SMRs when it comes to treating their own detainees they have. I'll leave it at that for the time being. Thank you.
Thank you so much, Mark. Pat, please.
Thank you very much, and again to USIP, thank you for the opportunity for us to showcase this very important issue. And Mark, it's very nice to meet you, and David, it's great to see you again. We frequently were sparring partners during the last 4 years. But I do want to clarify one thing. You know, for some reason, there seems to be a bit of surprise that the U.S. was so supportive of the SMRs. We actually are very committed to upholding human rights. That is something that is part of our national character. What I think people don't realize is that we are so fortunate in this country because we have a constitution, and that constitution embodies basic rights in it. Other countries don't have the benefit of that, and so other countries tend to look more to the framework of the United Nations and the United Nations framework of human rights as a way of incorporating those principles into their domestic practice. So I think from the outset that it's the different vision that the U.S. has from many other countries that at times it may look as though we're somewhat in opposition to human rights principles, but it's more the way they're articulated. And perhaps I should have put myself in between the two of you, because I think the role of the U.S. throughout these negotiations was to acknowledge the foundation of human rights, which frankly is what everything that we do in Vienna in the anti-crime world is based on. That's our foundation. So for us, it almost goes without saying, human rights is our starting point, but it's not our end point, because we strive to address administration of justice issues across the board. The SMRs, of course, is our flagship, if you will. It's the seminal achievement that was provided in 1955. And when we at the Crime Congress in El Salvador considered the issue of revising the SMRs, I have to say the U.S. was very hesitant. And we were hesitant because this was a system that works. And we knew that it had resonated worldwide down to the lowest levels, which is exactly where this is supposed to be. The SMRs is not the gold standard, it is the lowest standard. So it is to apply not only in upstate New York, but also it's to apply in Liberia and in places where they are challenged by resources and in other ways to implement the SMRs. So that's our main focus, to have simple, pragmatic rules that incorporate human rights and respect for human rights, but articulate it in a way that that prison guard sitting in Zaire or wherever he happens to be understands it in unequivocal, unambiguous terms. So that was why we were very hesitant in the beginning. And we agreed with some reluctance, but the reluctance was, we have to look to correctional science. We want this driven by science. We want it driven by best practices of member states. So those were our sort of conditions for agreeing to allow the SMRs to be updated. Now, what distinguished this series of negotiations from other groups that at least I've been involved in the UN was the tremendous groundwork that was done before the expert group actually got together on the part of NGOs, on the part of the UN Office on Drugs and Crime, to assemble, to assess, to get an idea not just of where the SMRs need to be revised, but where in the administration of justice are there issues and how can we update the SMRs to deal with that. So Mark, you mentioned overcrowding in prison. I mean, we recognize that that is a significant issue. And in the Crime Congress and the Crime Commission, we try to address the issue of overcrowding of prisons. But we also recognize that the individual manager of a prison has very little say-so about how he handles that issue. So we want to give them the basic guideline on this is what you do. And so we tried, and I have to, a little inside baseball. We weren't completely successful in articulating what we wanted in all cases. There's some language in one of the rules that addresses the principles of proportionality, legality, and necessity. And it says in conducting searches, there must be respect for human rights, but there must also be respect for these three principles. So we asked our practitioner who was accompanying us, what does that mean for you in practical terms? And he said, I don't know, I have to Google it. Well, so we want these rules to be understood without having to have access to the internet. And so while we were not able to get that term out of the SMRs, we were able to go back, sort of circle around to the other rules. And if you look closely at rules 50, 51, and 52, you'll see that we actually do describe what the principles of legality, necessity, and proportionality are with respect to searches and seizures. Now, looking at what we achieved over the nearly 5 years that we were negotiating this, I have to say I pinch myself because I don't know what the expectations of civil society were for an outcome, but as far as the United States, we got so much more in this than we ever thought possible. Perhaps it was timing. I mean, who knows what actually contributed to this. I really, personally, I think it was that we had such a great balance in the room. And when I say balance, I mean a balance not just of NGOs, but NGOs that had the perspective of working in prisons, NGOs that had the perspective of defending people's rights in courts with respect to human rights, NGOs who were looking at other issues. Maybe it was women and children or in prison or children in prison. So we had lots of different stakeholders, lots of different viewpoints. And then we had governments. We had governments who were very fearful of anything that looked like a commitment. It had to be political will was what we were going for. And then we had the practitioners. And I think this is where our meetings were so rich because we recognized all of these participants are stakeholders. We weren't drafting this for just one body, but our main focus was those people in the field. And as David said, the U.S. did invite Bernie Warner and Rick Ramish, who are respectively the head of corrections for the state of Washington and the head of corrections for the state of Colorado, to join us. They were not part of our delegation in South Africa, intentionally so, because we wanted them to participate as practitioners. And we didn't want there to be any suggestion of a government filter over the message that they were delivering. We wanted them there as experts in the field. And to the extent we were able to achieve significant changes, particularly in the area of solitary confinement, I think we have to look to those two practitioners, as well as to Lucky Manwetha, I'm going to mispronounce his name, our director of corrections from the state of from South Africa, who was also so instrumental. This was a very interesting part of the negotiations, where the practitioners were discussing among themselves how various countries refer to solitary confinement. And this led us to a kind of a definition. And the premise of our practitioners was, don't let them hide. Don't let them say, oh, well, this isn't solitary confinement, this is restrictive housing. And they were very forceful about this. We need to get this terminology in there so that the practitioners in the field will understand it doesn't matter how you describe it. If it's more than 22 hours in a day, it's solitary confinement. If it's more than 15 days in a row, it's prolonged solitary confinement. And we will not tolerate that. As an international standard, we will not accept that. And that's the message that needs to be carried. Now, there were other areas where we had huge successes that I think may not get the same attention that solitary confinement does. But we got reference to state responsibility where you have vulnerable individuals who have vulnerabilities in the prison population. What you don't see there is reference to the LGBT community, but that is where we in the United States and other delegations, what we were pushing for. We weren't successful. There have to be compromises, but that's what we were thinking of. If you see in Rule 2 and Rule 7A, I think there are references to this. So for us, it's a huge gain that we at least have a mention of vulnerabilities. And in 7A, we have the inclusion of self-gender identification in the intake files of prisoners when they come into prisons. This was probably, down to the wire, the most contentious thing we talked about, because there are many countries who any mention of gender issues was a non-starter for them. And we have to say, we're grateful to the government of Iran for conceding on that issue and allowing us to go forward. Because in our context in Vienna, in these negotiations, our premise has always been everything has to be agreed by everybody. This has to be a consensus document in order for us to get the global buy-in that is so necessary to make these successful. So it took many countries, ourselves and others, agreeing to language that maybe would not have been not only our starting point, but our concluding point, in order to get these rules forward. Now, what do we do from here? Well, in the State Department, I think our mission is to keep the focus going, not only on the rules themselves, but implementing the rules and using the rules as a tool to help identify those areas where countries need assistance. What we do in Vienna, what the State Department does in large measure, is identifying areas where other countries need assistance and seeking ways to provide that foreign assistance. So the rules can be a very helpful and useful tool for us. I think there's room for us in Vienna to talk about how we meaningfully follow up to the rules. From the very beginning, since 1955, there has been a provision in the rules themselves that requires member states to periodically update, and we do that through the Crime Commission. I think we need to look at that again and see if perhaps that mechanism needs to be adjusted in some way. We need to make sure, however we do this, that we continue this very rich and broad dialogue between academia, civil society, member states, and all of the practitioners in the field so that we get all of the concerns addressed. We're not going to solve this problem individually. Some say it takes a village. I think it takes a global community really to address a lot of these issues. But we've made a great start. I thank you all for your recognition of the role that the U.S. played. But I have to say, hands off to you all too, because we wouldn't have gotten there if it had not been civil society constantly pushing us to accept more than perhaps we would have done. And then your tolerance when we told you we've gone as far as we can go. So again, it's an excellent document. We want to see it adopted in the UN. I don't think there's any doubt that the General Assembly will adopt it. But then the next mission is to the practitioners in the field and you all to make sure that we implement this. But again, thank you very much. It was a wonderful experience and an enriching one. Thank you.
Thank you so much, Pat. Yeah, join me in thanking the panel. I think that the panel has taken us both sort of inside the negotiation process and inside the world of prisons in a really nice way, and now it's over to you for questions and answers session. And what I thought I might do is ask if you identify yourself and your affiliation when you ask your question. And then what we'll do is we'll finish with some closing remarks as well.
Good morning. My name is Marsha Wong. I'm with USAID, and I want to thank all the panelists for having this conversation today and helping us understand the behind-the-scenes negotiation environment and all the inputs that were received, because it does indeed take a very broad audience of willing people to tackle some of these challenges that you just laid out for us. My tendency, though, when I hear the unpacking of the big abstract and rules and frameworks, excuse me, is to go immediately to the micro. And Pat, I think you referred to the political will that will be needed from member countries. Can you describe a little bit of what kind of incentive structure that we can provide for that? Or other outside of just influence and diplomatic overtures, but how else can we look at it in a more granular way? That'd be very helpful. Thank you. And the question to all the panelists.
Maybe if I could start. So one simple way that we in the State Department already use the rules and serve as an incentive is when we are identifying domestic institutions that we would like to tap into to use as implementers to help us with training our foreign counterparts and partners, we insist that they must be able to establish that they meet the standards of the SMRs. So for us, that's, rule number one for us is you can't be an implementer for us unless you do that. We also try to make sure that member states get as much support as they can when they identify issues with implementing the SMRs. We also have been working very closely, as I said, with Bernie and Rick, and they are conduits to professional organizations. Because one thing to remember here is when we have binding documents, you have an agreement, that becomes an obligation of the state. The state forces it down. We don't have that structure here. So instead, this is more a bottom-up kind of structure where you encourage the practitioner in the field because this is what the professional in the field will strive to do. So if you are a corrections specialist, you want to be part of the professional community. And so that's one very effective way, we think, of working globally to raise these standards. Now, we certainly would be open to any other suggestions of ways that we might stimulate more adherence to and implementation and support for the rules.
Well, my perspective is, as someone who works primarily, indeed almost exclusively in the United States, and so let me answer the question in that context. I think Pat is exactly right. These rules are not, it's not a treaty, it's not a binding obligation, and so it really is about changing norms and culture and creating the perception that if you want to be on the leading edge, on the progressive edge of your profession, this is where it's at. These are the standards. These are the minimum standards that you need to apply. In the United States, we already have accreditation by the American Correctional Association. That has become a standard that many, if not most or all, prisons and jails aspire to. And so I think that we could do a similar thing with the Mandela Rules to make it really the standard in the profession that responsible and reputable corrections professionals adhere to.
Maybe just to add the bit of a global perspective to that as well, but also compel what you just said. Oftentimes we experience it not to be the issue of having the willingness or lack of incentive. It's just the matter of practically being able to implement things, having best practices, guidelines available, and then being able to find ways to implement them with other stakeholders as well, with people with expertise, to get to the place that are stipulated in those guidelines. Oftentimes, it's clear to governments or to other stakeholders where the benefits lie to have a humane detention. It's not something that they don't see. It's something that they maybe don't put enough attention on, maybe they don't put enough resources on it, fair enough. But there are often ways to get there by just making people aware, having those guidelines disseminated, and then finding practical solutions.
Mm-hmm.
Hi, my name is Ruth Sear, and I've run programs in a number of prisons, and I've done criminal justice scholarship. So I am a little bit skeptical, and these norms seem to me to be very aspirational. So, in the history of criminal justice scholarship, typically prisons are seen to be, needing to have less eligibility, so to speak. That whatever the norm is in the general culture, prison standards should be lower, not higher than what's in the general culture. And in many ways, these standards may be, if implemented, would be, have a higher standard of services and then available to the general populace. So how, in countries that are very poor, how do you expect prisons to be able to implement these standards when the general population is poor and destitute?
I'm going to start here.
That is not an argument that's limited to countries where people are poor and destitute. We hear this in the United States all the time. What? They get free health care? I don't get free health care. And you're right that these rules are aspirational. I don't think there's a single country in the world, even those with the most progressive prison systems, that complies with all of the rules. But I think having it out there as a norm is important in and of itself for the reasons we've described. And as for the why do prisoners get this argument, the response is that when the state takes you into custody and disables you from providing for your own needs, the state takes on a corresponding obligation to provide for your needs. Some people don't find that persuasive, but that's, as far as I know, that's the best answer we've got.
Maybe just to add to that, in practice from our side in the ICRC, we don't expect certain countries from trying to come to a certain level of services and care than maybe we expected in other countries. There have to be localized adoptions and adaptations to whatever the rules stipulate, but of course still bearing in mind and respecting the basic norms of humanity in prison as well. But yes, in a prison, you mentioned Zaire or DRC, in eastern southern Katanga or something, we wouldn't expect the same kind of provisions of services as maybe in a prison in Europe or something else.
Here.
Hi, good morning. My name is Mary Greer, and I work at the American Bar Association Rule of Law Initiative. Thanks to the panelists of the USIP, and it is a good way to end the week, to hear this good news. I wondered if you had any advice for us. We do a lot of technical assistance, mostly at the pretrial stages in detention facilities, not so much correctional facilities, but do any of the panelists have any advice for us in terms of any guidance on technical assistance generally, given the new mandates of the Mandela Rules?
Well, I would start by looking at the provisions in the rules that address the pretrial confinees. And, if it's in terms of a technical guide, we're hoping at some point that we will see a document that basically reduces the rules to a checklist almost, not for an outside assessment so much as for an internal self-assessment, so that the institution itself can say, okay, this is the standard, the minimum standard we want to achieve, we're deficient here, we've made it here, and so forth. So with respect to the issue you're looking at, I think we've made some changes that deal specifically with pretrial detainees and access to legal assistance, that sort of thing. So I would look at those and perhaps see if you can come up with some limited kind of technical blurb that you could then have available when you go to various institutions to say, gee, are you aware the new guidelines? This is what the global community has said they've agreed to as a minimum standard.
My name is Charles Sullivan, and I'm a director of an organization called International Cure. My response, and let me say David is a very dear friend and one of my heroes. My response is very much the opposite of this lady. I'm very disappointed. I don't see that much of a change. Good example, if we're serious about using human rights, Article 21 of the Universal Declaration, which is also Article 25 of the Covenant on Civil and Political Rights, talks about voting. I don't see voting as a right, an absolute right. Maybe there was discussion of voting, but I don't see anything there. There is a big change in regard to, and maybe David would agree with this, in regard to people in jail. We have 13 million people in and out of jails every year in this country. So being able to have some way of being different from they usually are typically in uniforms, etc., receive everything that a sentence prisoner would receive. So that is a good change. But the responsibility, to me, of the whole process should be the responsibility of the states, not just healthcare. It's a responsibility of the state. When you lock someone up and take away their freedom, you have an obligation not only to maintain their health care, but to maintain their books, whatever it is. So I would see at the beginning that in all four categories, it is the responsibility of the state to provide the expense. Not this whole idea, to me, scratching, doing it on your own expense at all. To me, the problem I see, even internationally and certainly here in this country as well, is we have so many pretrial detainees. If they're going to pay for their pretrial detaineeship, if they're going to pay for it, what is the incentive to release them? What we have to do when you have 75 and 80% of countries having their people in pretrial detainees, we ought to make the system financially responsible for every single concern they have. Or we're never going to have a release, a substantial reduction in pretrial detainees. And by taking and providing that you can do it out of your own. Let me just quickly...
Just one more point and then we'll let them come back or we'll lose track.
Community standards. And I realize when you open up windows and you have air, etc., there may not be air conditioning or climate control. We're talking about cold, being cold in the winter as well. But if it is like right now in Texas, air conditioning is something that everyone is considered a way of living. And yet the prisons in Texas are not air conditioned. And people are dying every year with the whole thing going on now with climate control. Well, it seems to me that there should be some type of community, where the community is, there should be a concern translated into the prisons and jails. Now, I'm not saying higher than the community, but at least the minimum standards operational in the community. And let me just end with this. And that would be with regard to communications, phones and email. Why don't we, was that discussed? I'm not saying that in the middle of Africa where there is no phones or email, for some people, fine, in that community. But where there is, there should be also an outreach. And now we're talking about reasonable phone. We have a situation in this country that is unbelievable in regard to corporations charging phones, which David and all of us know about. Okay, so that's it.
Thank you, Mr. Charles. And I actually think that this is not just an opinion of yours. This is definitely one of the criticism. What do you think, panelists?
Well, let me say one thing. I think the question itself underscores the importance of civil society bringing these kinds of issues to the forefront. Not everything that you raised actually was considered by the experts. I don't think we addressed the issue of voting when we talked about revisions to the rules. When we left Vienna, I must say I got together with our two individual state experts and said, well, looking back on this process, what did we miss? And because I assume, we did miss some things. And what they said to us was, well, you never touched race relations, which is a major issue in prison administration. And David and I had a brief conversation about this. Perhaps there is language that we could look to where we did, in fact, address this, but no, we didn't do it head on. So this then leads to a conclusion that there has to be a continuing dialogue. If we come away with one lesson for those of us in the diplomatic community, it's that we can't wait another 60 years to revise the rules. We have to have a better process for meeting with civil society, meeting with all the various stakeholders, and finding out within the industry, within the areas of concern, what are the issues that we should be looking at. Now, the last thing when you talk about telephones, I believe we intentionally circumvented that issue because not all countries have the same telecommunications system. So I think we talk in terms of contact. If you look carefully at the rules, we talk about the ability of prisoners to have contact with the outside, contact with the family. So we didn't specifically address the instruments of contact, and maybe that's something we should in the future. But at least we thought we were addressing it by being more generalized and focusing on the reason that we allow communication.
Mark?
Yeah, maybe on that last part, just to add, fully agree that different contexts require and can be expected to have different solutions. From the family contact side of things, yes, maybe many countries, many contexts allow for family visits. If that's not possible, maybe then there's other means or measures. I mean, speaking of Africa, in my experience, cell phones are almost global now, globally available, even when there's no electricity and no running water, but cell phones somehow still main feature. So that's one of course, one way one can also rely on if visits are not possible, or in addition to visits. And then there are other measures, of course. The good old snail mail still exists somewhere as well and provides its benefits, but it's the whole plethora of family link communication avenues that needs to be looked at in order to have that. And I don't know, I said I wasn't part of the revision process, but having that notion of the importance of family contact in there, and then of course contextualize it and trying to find local solutions to implement it, that's the key step to be taken.
Well, of course, you're right that the rules aren't perfect and could have gone further, but as I've mentioned, they are the result of many compromises, taking into account the varying conditions, in various parts of the world. I will point out that temperature and ventilation are addressed in Rules 13 and 42. And communication is addressed in Rule 58, where it says, and Pat pointed this out, corresponding in writing and using, where available, telecommunication, electronic, digital, and other means. So it's in there. And I would just take this opportunity to encourage everyone to read this document. It is an amazingly comprehensive document. I've read it I don't know how many times, and every time I read it, I see something new that I hadn't noticed before. So I encourage you all to read it often.
So, gentleman at the back here.
Hi, I'm Paul Wright. I'm the editor of Prison Legal News. One of the things is, so it's become abundantly clear that this is an aspirational document, and there's no means for enforcement. And I think that one of the things that, to the extent that we report mostly on prison conditions here in the United States, we also have international coverage. But it's one of those things when we see, for example, the United States is holding this up as an aspirational document, yet we know that at the New York Times just did a big piece recently about federal prisoners being kept in prolonged confinement for decades on end at the ADX Supermax held by the Federal Bureau of Prisons. On any given day, we've got 80,000 prisoners being held in long-term solitary confinement here. Our organization routinely challenges things like bans on books and letters. We're fighting to uphold the right for a 15th century means of communication. So at what point does this trickle down? And I think that one of the things that we've seen is that, especially at the local level, prisons and jails, at least in this country, have been remarkably resistant to any type of change and any type of oversight or anything that limits their discretion or their desire to run things the way they see fit has, that's been pretty much the way it's been for several hundred years now. At what point does this trickle down if there's no enforcement mechanism?
Well, since you're talking primarily about the United States, let me take the first crack at answering. And it trickles down. The answer is, I think it depends. It trickles down differently in different places. I mean, the United States government is a strong supporter of these rules. So I assume in the Federal Bureau of Prisons, we will see some deliberate effort to comply with them. State prison systems obviously are independent, and there's a lot of variation in the philosophy and outlook of the people who run them. So I think the Bernie Warners and the Rick Ramishes, the two people who are part of the U.S. delegation, are going to be paying more attention to this than people in other states. And as you said, the place where it's probably going to be slowest and most intermittent is going to be local jails, which are, again, largely independent, and some of them really quite cut off from the mainstream of correctional thought. So I don't know. That's probably not a satisfying answer, but I do think that it's going to depend on the extent to which this becomes a norm that's accepted by the people who run these facilities.
If I may, the issue you raise is one that we discussed when we were talking about the revision of the rules. And it is really sort of the fundamental difference between having an aspirational document, as you call it, or what we call soft law, and the more hard law treaties. The value of soft law for us is that what we achieved in the SMRs, we would never get in a binding agreement, because we would have to go to the Department of Justice, and the Department of Justice, at least on the U.S. side, would look at this and say, all we can agree to is what the Constitution of the United States mandates. And so we would be limited. We wouldn't have had perhaps the same language on search and seizure. We wouldn't have had the same language on LGBT. We wouldn't have had the same language on even ventilation and so the lesson here, and I suppose it's a philosophical one, is do you try to get more through the soft law approach and recognize you're not going to have an enforcement mechanism, but you will have a desire to implement. It's a standard, and people want to be part of the professional association. So we're pushing from the bottom. My view, these are more achievable this way than if we tried to do it through hard law. as I look through the various things that the UN has achieved, and now I was remiss in not mentioning this earlier, and there goes my stupid thing again, sorry. This is the compendium that is put out by the UN Office on Drugs and Crime. And this contains all of the various standards and norms in crime prevention and criminal justice that have been agreed to in Vienna. And they cover not just the SMRs, but they talk about the deprivation of children, deprivation of liberty of children. They talk about women in confinement. They talk about alternatives to confinement. So lots of good information in here. And these are the result of member states, practitioners, everybody getting together and identifying what should we be doing, what can we be doing, not what is the limit that we as governments can agree to. So I know I'm sort of getting on the soapbox, but between the two, we've seen results, albeit slow, in a more significant way than I think we have achieved through some of our binding documents.
And let me just add that in some cases, soft law can sort of bleed into and influence hard law. In the United States Supreme Court, in a case called Estelle versus Gamble, which is the seminal case on prisoners' right to health care, cites the SMRs. Lower federal courts have cited the SMRs on things like restraint of pregnant women in prison, on the practice of requiring prisoners to sleep on the floor without adequate bedding. Now, in no case did the court, rest its decision on the SMRs as binding law, because they're not, but it did cite them as informing its analysis and its decision under U.S. domestic law. So the line between soft law and enforceable law is not always as clear as one might think.
Hi, my name is Emily. I'm a student at American University studying justice and human rights, and I'm also a reporter for Wall Street Media. So my question is about private prisons. So something like 8.5% of the U.S. prison population is currently detained in private prisons. And so as you said, this is not mandated law. This is not a treaty that must be ratified. These are basically just suggestions for minimum humane treatment of prisoners that are basically backed by prestigious groups who say this is how you should treat our prisoners, and with the hopes that these prisons in our country and elsewhere will abide by those minimum rules. But you also express that these will hopefully be abided by because there is a benefit in treating prisoners like human beings. But the Corrections Corporation of America, specifically the largest private prison industry in the country, is, universities and companies across the country invest in this corporation and reap benefits from having people detained in private prisons. So my question is, how do we ensure that these minimum rules will be followed when the benefits do not lie in having a humane detention, specifically in the private prison industry?
Well, full disclosure, the ACLU has, as a matter of policy, opposes private prisons because we believe that incarceration is a core governmental function that, if it is to be done, must be carried out by a democratically accountable state. So that's our view on private prisons. We believe that the model of private incarceration sets up problematic incentive structures that can lead to bad outcomes. But with regard to your specific question, as a matter of U.S. law, it's clear that the custodian of the prisoner is always the state. The state can contract with a private company to provide various services, if I can use that word, but there's no question, it's absolutely uncontroversial that legally that prisoner is in the custody of the state. So the obligation, it's not an obligation because these rules aren't binding, but the desirability of complying with the SMRs, with the Mandela Rules, isn't affected by the fact that the state contracts certain functions to private corporations.
If I may, I would add, I'm not sure I'm comfortable with the description of these as just being the suggestion of some practitioners in the field. these were a product of the United Nations Program on Crime Prevention and Criminal Justice. That program consists of a United Nations Crime Congress, which meets once every 5 years and is open to all member states of the United Nations, 198 of them, plus observers and NGOs, practitioners, academicians, a whole array of people are invited to and encouraged to and do participate in the Crime Congress. The policy-making body of the UN with respect to law enforcement issues is the Commission on Crime Prevention and Criminal Justice, which is the body that adopted these. There are 40 member states that are appointed to the Crime Commission. They have to be elected by the other member states. They represent the interests of the 198. These rules were adopted by the Commission and sent forward to the General Assembly unanimously. That means all 40 members of the Crime Commission agreed to these rules, and now they'll go to the UN. In the UN, I suspect they will be adopted again by acclamation, probably by consensus, probably 190, I would say 7, would vote. You know, there's always 1 or 2 that won't support. And some of the issues we talked about today may, in fact, cause some to issue explanations of position or something of that sort. That is tremendous weight. That is the opinion of the world, not just a few countries or a few NGOs. It is both governments, practitioners, NGOs. We're all in this together. Obviously, I can't, you know, as a representative of the U.S., say how other states or you know, entities should apply the SMRs to their contracts. But one would think that if the United States government has supported these, we would support them throughout the entire array and ask the question of the contractors who are, again, acting for the state, why they're not using the rules. I think it's a very valid question and one that should be raised. So I you know, would think that would be an area for further attention.
Yeah, just a general remark maybe to add, independent of whether the prison system is maybe run by a private company or by the state, of course the inspecting mechanisms, the compliance oversight mechanisms have to be clear. They have to be independent bodies, they have to be done regularly. And those questions, maybe yes, maybe it's more valid even if it's run by a private sector company who of course has profits in mind, maybe a priori than other things. But in general, that's the inspections, the compliance mechanisms. This is something that makes or breaks rules like this, of course.
Middle here.
I'm Jenny Tumis from the National Democratic Institute. I just want to thank everyone for speaking. My question is something that, Mark, you already addressed briefly, but I'm wondering how much the changing nature and global nature of detainment went into your discussion. You mentioned, for example, prisoners in Yemen being detained in the United States or other places in Europe, and I'm just wondering how this changing nature and increasingly global nature of detainment, where people are not necessarily detained in their home country because of things like the war on terror, went into this discussion. Yeah, thank you.
Well, I can briefly address how it went into our discussions, because the mandate to revise the rules came from the Crime Commission, and the Crime Commission deals with anti-crime issues. We don't deal with extraordinary law issues or with non-judicial issues. So we were focused on prisons and prison administration. There is a provision in the rules, though, that says that they can be applied more broadly. It was not our task at this revision to revise those rules. So as the revision takes place, it also applies, and member states can apply them to other categories of detainees. They also reflect best practices, and so as such, best practices would apply to individuals detained, whatever the basis for the reason is.
Just generally, maybe to add what I mentioned before in that respect, yes, globalization, people moving around, having then family connections that span the globe. And of course, one can imagine in situations where somebody ends up in prison, you know, independent of war and terror and other circumstances, but more generally, and all of a sudden many of the rules that we see here and the the high value of them become even more complex than to implement because of that nature of having global connections and family members all over the place, for example. And then, of course, the adaptation of the rules to those circumstances is not easy. So there again, I mean, you have means like technology and other means to maybe help, but it's even more complex than that.
As Pat said, it was not a big part of the discussion. I mean, it was in the background, and you'll see in the rules a couple of places where there was mentions of there are provisions made for prisoners who don't speak the predominant language. They have the right to interpreter, and I believe there's something in here about the right to access to your consular officials for prisoners who are not citizens or nationals of the place where they're incarcerated. So it's acknowledged in that way, but it wasn't a huge part of the discussion.
Another couple of questions over here, perhaps, and then we'll take some.
Thank you all so much for talking to us. My name is Josh Aiken. I'm with Human Rights Watch. I'm also a student who does graduate research on LGBT populations in prisons, and so I wanted to ask specifically about 7A and what the conversation was to have prison files include gender self-perception, and what the power you see in including that in maybe this draft of the Mandela Rules is, and then what you might see down the road, and kind of the limitations of just including that in the prison file, but it not necessarily having any teeth to, for instance, have a trans woman be put in a women's facility. And so kind of what the conversation was like.
Well, it was an interesting conversation because, we have a lot of views from the Western world, and then a lot of views that were from other countries, particularly in Africa, where even discussion of this kind of issue is not acceptable. And so getting the issue on the table was probably as difficult as getting any language in the SMRs. As I mentioned, I thought we were very fortunate to get some mention, and it was largely due to interventions where our practitioners were able to say that this is a major problem. When somebody comes into a prison and the prison officials decide what their gender is, that is going to impact that individual for the rest of their prison time. And, again, it's about respect and dignity of the prisoners. So it's important to allow those individuals to be able to self-identify, and that should go in their file. But their file, and this is another issue we address, the file is to be confidential. It is not, it's to be available only to those people in the prison system and in the administration of justice who have an official reason to know what's in there.
Take another one. Question here.
Hi, my name is Tigist. I'm an intern at the Syrian American Medical Society. My question is on the topic of healthcare, providing healthcare in the prison facilities. How would you go about, or can you talk a little more about how INGOs or NGOs can offer prisoner states that can't provide their prisoners healthcare, how they can do it, how NGOs can provide this?
Speaking generally, of course, we do, if circumstances require it, life-saving circumstances or really infrastructure that is otherwise not able, we do try and support prison systems via the ICRC medical support systems that are available. We have detention doctors, we have surgeons, but of course we normally look more at systems in terms of how the prison system is able to cater to the health needs of the detainees and therefore make recommendations. If things are so dire, I'm thinking maybe Rwanda in the 90s, etc., that the state is basically totally incapable to still cater to those needs, then of course the substitution can be another way of addressing issues. But it's otherwise more the idea to support the system with our expertise and then find sustainable solutions, because it's one thing to support and substitute for a short time, but then of course long term it should be the state taking charge of the detainees and having those obligations to cater for the basic needs in terms of healthcare.
Take one final question here.
Hi, Mike Garber, Office of Military Commissions. So I have a larger question, sort of building on what she was asking before. What's the applicability and compliance with the old standards, I guess, for the RDI program, and what would be the applicability and compliance with, I guess, both set of standards at Guantanamo Bay?
You first.
Look, as I said before, we consider those guidelines really as a practical guidance for prison administrations at large. Looking at Gitmo, looking at Guantanamo, of course, there's also other guidelines, other rules that are applying. I think looking at the comprehensiveness of these rules, giving food for thought, best practices, I wouldn't exclude that there's something also for Gitmo to be used. But a priori, there's a lot of other rules and systems that already can be used and that we are also using. I would leave it at that regarding Gitmo.
Well, I'll point out that the very last rule, Rule 122, persons arrested or detained without charge, says that such persons are to be accorded the same protection as that accorded in Part 1. Part 1 is the rules that apply generally, and Part 2, Section C, which is prisoners under arrest or awaiting trial. So this seems to say that they would apply.
Okay, we'll take one more question and then have some closing remarks. You have one more?
Are the ACA, is that a mechanism that can be used to implement mandates or any of the discussions about doing that?
That's an interesting question. I know that these two corrections officials obviously have discussions with the ACA. In fact, I'm on a panel with one of them at the ACA National Conference next month. That's an interesting idea. I don't know if those discussions have happened, but they probably should, because it's a very similar, while ACA does provide a formal accreditation and has a formal sort of review process, the standards are very similar in that they're both voluntary, aspirational. So I will raise that question with some people. Thank you.
And now, thanking the panel, it is my pleasure to introduce to you Ambassador Luis Arreaga, who is the Principal Deputy Assistant Secretary of the Bureau of International Narcotics and Law Enforcement Affairs, the lead US entity in the negotiations of the Standard Minimum Rules. Luis Arreaga is a career member of the Foreign Service, had a celebrated career recently as ambassador to the Republic of Iceland, also serving in missions in Panama, in Canada, in Geneva, Spain, Peru, El Salvador, Honduras. And indeed that Ambassador Arreaga is originally from and raised in Guatemala before immigrating to the United States. Welcome and thank you for joining us.
Thank you very much. Thank you very much. And don't let that introduction fool you. I'm just a regular guy, a campesino from Guatemala, delighted to be here and to thank USIP for organizing this wonderful event and providing an opportunity to discuss this very important issue. Nelson Mandela once stated that no one truly knows a nation until one has seen its jails. A nation should not be judged by how it treats its highest citizens, but its lowest ones. We heard and said this many times in Vienna, where the international community came together to debate the question of whether to adopt the revised SMRs and whether to call them the Mandela Rules. The United States devoted a tremendous amount of effort to get to that point. The standard rules had not been updated since 1955, something that I'm sure you all know. Our goal was fairly simple. We wanted to develop universal guidelines to make correction systems safe, secure, humane, and transparent. Our journey to Vienna drew on unique expertise and experience from throughout the United States. The U.S. contingent included experts from federal, state, local prison agencies, as well as NGOs with expertise in criminal justice matters. In other words, the revised rules are not the product of conversations between striped-pant diplomats in Vienna. They actually reflect the collective expertise of corrections professionals from around the world, as well as guidance from civil society groups such as the ACLU and Penal Reform International. Their representatives participated in many of the discussions over the past 5 years, and this was most evident recently during the last round of expert discussions in Cape Town this past March, when we worked alongside officials from the Colorado and Washington Departments of Corrections. These officials provided some very compelling lessons learned in prisons management and corrections. For us, the success of this effort reinforced the importance of working closely with civil society and other experts in future efforts to shape global criminal justice. So while gaining agreement on the revised rules is a major achievement, we must come together again and bring them into practice. Now, like all challenges, that will be easier said than done. We will need a judicious blend of diplomacy, advocacy, legal reform, and technical assistance. The office that I represent, the State Department's Bureau of International Narcotics and Law Enforcement Affairs, is already working on this. We are incorporating the revised rules into the corrections training curricula that we use around the world. We are incorporating the revised rules anytime a partner nation wants our views on draft legislation on prisons. And we are continuing to look for other opportunities to make practical use of these revised rules, and we certainly are open to your suggestions. Now, before leaving you, let me suggest that we take time tomorrow, when we celebrate Mandela Day, to reflect on how we can walk together in his shoes and continue our efforts to effect change for those who are most vulnerable and need it the most. Let's put the revised SMRs into action. Thank you very much.
Thank you very much for joining us here at USIP today. And thank you very much to Ambassador Arreaga for those closing remarks, and to the panel for discussing so intelligently and in depth today. There are copies, if you haven't picked one up, of the SMRs out on the table, and I would encourage you all to read them, reread them, pop them in your back pocket, stick them in your handbag, and thank you very much.